Okay. Shh. Welcome back. Welcome back. If you celebrated Yom Kippur, hope you had a good fast. If you didn't, I hope you had a good night anyway. Questions about last class? Questions about Dred Scott? No? Okay. Let's start with a poll question. And this is another question that I don't think has a right answer, but I want to see how you guys answer it based on your reading. So the question is this. The framers of the 13th, 14th, and 15th Amendments intended those provisions to protect the freedmen, that is, the freed slaves. Okay. True or false? Yeah.
Do you mean intended to only protect them?
Read the question and answer it. It's a true or false question, my friend. You're thinking way too hard.
Sufficiently ambiguous.
No, I know. All right, another 10 seconds or so. Okay, let's see what we got. Again, I don't think there's a right answer to this one. So about 2/3 of you said it's true, and about 1/3 of you says false. Okay. Again, I'm not saying it's a right or wrong answer here, but the reason why I put this question here is to understand slaughterhouse. Right? Let's think of our history. When the Constitution was ratified in 1789, it had these references to slavery, but didn't actually use the word. So the Constitution was largely silent on the precise issue, although it sort of talked around it. But Congress was not silent. We know that Congress enacted the Fugitive Slave Act, which we talked about in Prig, which expressly allowed for slave catchers to kidnap people and bring them down south. We talked about the Missouri Compromise. This was the agreement by which certain new states added to the Union would be free, and other new states added to the Union would be slave. And then we get to Dred Scott, right? This anti-canon decision. And Dred Scott was a 7-2 case where the court held that slaves could never be free, and people of African descent could never be citizens no matter what their states did. And then we had this bloody Civil War, right? President Lincoln famously said, "A house divided cannot stand. You can't have half slave, half free." And then after this bloody Civil War, we had this ratification process where the 13th Amendment was ratified. The 14th Amendment was ratified. The 15th Amendment was ratified, right? You have this nearly 100-year history with these radical changes in our laws in less than a decade. Then we get to the Supreme Court, right? And the Supreme Court begins to understand what the heck just happened, right? What happened with the 13th Amendment? What happened with the 14th Amendment? There are some 15th Amendment cases. We won't cover them here, but there were cases on that as well. And what we find, by and large, is that the court, for whatever reason, wasn't willing to embrace a radical change in how things were. In other words, the court recognized that some stuff was different, but not that much. And they largely answer this question as true, right? that these amendments were designed to protect the freedmen, the freed slaves. But by answering this question true, the Supreme Court offered a very cramped interpretation of these provisions. In short, according to the court, the only thing these amendments did was to basically emancipate the slaves, was to free them from physical bondage, and not much more than that. And these cases give rise to a question, right? How do you interpret a legal text? Do you interpret a text based on the intentions of the framers? Or do you interpret a text based on the meaning of the words they chose? Very often they're not the same, right? Very often you might have one thing in mind, but the words you choose extend to other situations. And I'll give you a very easy example, right? The 14th Amendment Privileges or Immunities Clause says, no state shall make or enforce any law which will abridge the privileges or immunities of citizens of the United States. It doesn't say men. It says citizens, which could be a man or a woman. You have the Due Process Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. It doesn't say men. It says person. Person can be a man or a woman. Now, do you think that those who framed the 14th Amendment intended to give women the right to work as an attorney or whatever else you had in mind? Probably not, right? If you were to poll them, they probably agree with Justice Miller, the majority, right? They probably said, no, we don't want women to be attorneys. That's not what this is about. But they use words whose meaning was bigger than what they intended. And I think you can use a similar analogy for the framers of the Constitution, right? They had different perspectives on slavery, right? I'm sure there were some framers from the North who wanted to get rid of it, and there were some framers in the South who wanted to keep it. And the compromise they reached was to be silent about it, right? You have Thomas Jefferson with the Declaration of Independence, who was largely someone who supported slavery, although it was complicated. But he wrote a phrase, all men are created equal. He wrote it. He didn't have to say that. He wrote that. Right? He goes that all white men were created equal, but he didn't write that. Very often by choosing words, you lock yourself into things that you don't quite anticipate. And that's why most modern constitutional theorists focus on the meaning of the text and not how they would have intended it to operate. Because if you limit your understanding to what their intent is, it can be very complicated. There might be hundreds of people who vote on it. How do you know what they all intended? How do you say, well, this group intended X and that group intended Y? How do you reconcile those? So the better approach, at least the one most modern theorists apply, is to look at what the meaning of the words they chose. And in this case, well, actually these cases, Slaughterhouse and Bradwell, the first two cases for today, the meaning of the words they chose were quite broad. But then the Supreme Court says, forget that meaning, let's go based on what the framers intended. So you see this sort of a struggle between meaning and intent, and depending if you use intent, it's very narrow, and meaning can be much broader. Okay? Everyone okay with that so far? Now, oh yes, sir.
Was it easier for the courts, seeing it they were like only 3 years
Yeah.
after
Yeah.
to come up with what the intent of the framers was, rather than
Yeah. Yeah, there was one line, I think it was in Slaughterhouse, that says this history is fresh in our mind, right? Yeah, that one line there.
light history.
Yeah. It's only a couple years old. But even then, Serge, let me ask you a follow-up question, if I may. We have a question on the Bank of the United States, right, which was enacted, what, a year or two after the Constitution was written. Madison and Jefferson thought, no, you can't do this. Hamilton said, yes, you can. Which framer's intent should we listen to? Hamilton or Madison, right? So even when you have these other historical eras where history was fresh, you still had conflicts between the framers' intent. Now, Marshall didn't really resolve it based on Hamilton or Jefferson. He resolved it based on what he thought the word necessary meant. He actually looked to meaning. Of course, he stole Hamilton's argument what the word necessary meant. But you always have these cases where, I'll give you a contemporary example. I don't like talking about contemporary cases much, but this one's relevant, right? Argued at the Supreme Court this week. In 1964, Congress enacted the Civil Rights Act. We studied this in the context of Heart of Atlanta Motel and Ollie's Barbecue, Katzenbach, right? And part of the law said that places of public accommodation cannot discriminate on the basis of race, right? Which means you can't turn away a customer for being black, for example. And the court upheld that. But another portion of that law, called Title VII, said that you cannot discriminate on the basis of sex. I'm sorry, let me be precise. You can't discriminate because of sex. That's the word that's used, because of sex. All right, what does because of sex mean? Now, if you were to poll people in the 1960s voting for this, did they mean to, for example, prohibit sexual harassment, which is a term that's well known now, but didn't really exist in the 1960s? The short answer is probably not. They didn't even know what that was. Think of like a show like Mad Men, right? One of these shows in the 60s where women were treated like crap in the office, right? That was pretty common. Did Congress mean to eliminate that? Probably not. But the court said because of sex means that sex plays a role in the discrimination, and sexual harassment is such an instance. Okay. What about if a person is gay or lesbian, right? Is discrimination on the basis of sex including LGBT discrimination? Now, when the Civil Rights Act was passed in '64, it was quite literally a crime to be gay. It was against the law. And the American Medical Association considered it a mental disability, right? It was literally like a sickness, right? So if you were to poll the members of Congress of their intentions in the 1960s, saying, do you mean to protect gays and lesbians in the workforce? I am fairly confident that everyone would say, of course not. No, that's insane. We would never want to. But just this week, you have a case in the Supreme Court asking, what does it mean to discriminate because of sex? That is, if a person is attracted to a man, that's okay if the person's a woman, but not okay if the person's a man. Is that discrimination on the basis of sex? Now, this is not a constitutional decision. This is a statutory decision. And I'll leave aside whether you should read statutes with the same sort of broad scope as you would a constitutional provision. But here we have a statute enacted in our lifetimes. 50 years ago, people were still alive who were alive in the 60s. I'm sure we could ask people, what did you think in the 60s this meant? They're still alive, they're still around. So the court, even the court's more progressive members, were saying, no, we can't look at their intentions. That doesn't control, right? We have to look at what the words mean. And very often, the words that were chosen in the 1960s may be broader than the intentions of those who wrote those words. So a lesson, always be careful when you put something in writing, because it may do stuff that you don't intend. It may go beyond what you thought it would be there. That makes sense? I haven't had time to read the transcript entirely for the gay rights case this week. I haven't had a chance to. I've been really busy this week, holidays and stuff, but I will read it eventually. I'll get back to it. And if you want, tomorrow the oral arguments are always posted on Fridays. If you want to listen to it, it should be online tomorrow on the Supreme Court's website. No cameras, just audio. All right, but let's go back to our poll question. Nick kind of ruined it before with this question. So Nick, the word only is not in there, is it, my friend? No. I think that's the rub, right? I think he asked the question I was going to ask someone else, but he gets my question, unfortunately. I didn't say only intended. just say they intended. And I think that's sort of nuance I'm trying to get at with all of you. No doubt, part of their intent was to help the freedmen. But their words were broader. And there were some members who drafted it that knew they were going beyond helping the freedmen. Now, does that mean you help the butchers in New Orleans? Does that mean you help the lawyer from Illinois, Mrs. Bradwell? Does that mean you help victims of a violent lynching in Cruikshank? Right? How far does that go? And in these three cases, Slaughterhouse, Bradwell, and Cruikshank, the court basically slammed the door shut on the privileges or immunities clause. I'll get to the cases in a minute, but I want to just give you some background. Almost everyone today agrees these cases were wrongly decided as an original matter, right? There are very few people who say, you know what, these cases are right. And there's a very robust effort among some constitutional lawyers to try and get the court to overrule these cases. So far, no good. So far, no luck, right? So far, there's a grand total of 1 vote to overrule Cruikshank. Justice Thomas. Justice Gorsuch signaled he might be willing to revisit it. We'll see. 1 second. Kavanaugh was silent. So far, we have a grand total of 1 vote. That's all we got. Yeah, David.
How do they overrule it? Do they have another case that brings the same?
Yes. That's right. So, the court can't just wake up and say, you know what, we want to overrule a case today. Go away. Right? That's not how it works. You basically have to have a litigant who goes to the court asking to overrule a case. Okay. In 2010, I might be off in a year, but I think 2010, the court had a case called McDonald v. Chicago. And the issue of McDonald was this. The court had held the Second Amendment limits the federal government, right? That the District of Columbia, a federal territory, cannot ban handguns. But what about Chicago, a state, right? It's a city within a state, but it's a state. And the plaintiffs in that case asked the court to overrule Cruikshank and say that, in fact, the Second Amendment was a privilege or immunity of citizenship. I worked a lot in that case, did not get very far. Only Justice Thomas was willing to overrule Cruikshank. He said it's not a precedent entitled to any respect, which I think he's right about that. The other justices, both liberal and conservative, said, well, we're not going to go that far. We're not going to rule Cruikshank. We're going to leave it in place. Now, why were they willing to leave Cruikshank in place? Not because they like it. It was an awful decision. I think you all had to read it. It's not a good case to read, right? But the problem is twofold, right? One, notice how it only applies to citizens, right? The privileges or immunities clause, at least based on its text, I'm not even sure if this is right, but I think the way people read it today, I have doubts, but is that it only protects rights of citizens. All right, well, if you're a non-citizen, right, do you start losing rights? Because the court has said a lot of non-citizens gets rights. Now, for example, if you're in this country and you're an immigrant, for example, you're not a citizen, and you're pulled over, can the cops search your stuff without a warrant? No. The same sorts of rules that apply to persons apply to citizens. That apply to non-citizens apply to citizens. Same rules. Right? So I think there's some hesitancy about going back and using privileges or immunities because of the citizenship question, right? The other issue is there's this fear that, oh my God, what are these privileges and immunities? We'll have courts making up rights out of whole cloth. So the conservatives don't want to do it because they don't want to make stuff up. And the liberals don't want to do it because they don't want to deny rights to non-citizens. So this weird, it's like Venn diagram where neither side wants it, except for Justice Thomas doesn't care. It just doesn't matter to him. He says, I'm going to get it right, results be damned. And that's why Justice Thomas is Justice Thomas. He doesn't care. He's like, he says, if this, what's the phrase? I think he said, so be it. Like, if this screws stuff up, so be it, right? That's what we got. Anyway, but I at least respect Thomas for saying Cruikshank was wrong, because it was. Okay. But thank you, Nick, for stealing my thunder. Mostly joking. No, these questions are framed in a very deliberate fashion to try and highlight a fracture, where if you miss a word or two, it goes one way or the other. That's why I frame these in a certain way. I do the same thing in property. It's less obvious, but here you can see it a little easier. All right. Yes, ma'am. Oh boy. Well, the questions in the finals are fact patterns, open-ended. So I choose my words carefully. Like
That's
you.
all I was really asking.
Yeah. Oh my, yeah. My goodness.
The words, like,
Read every
the
sentence.
words.
Yeah. I choose my. I mean, it takes me almost a full day to write a question. It's not a quick process. I spend hours laboring over every single sentence because think about it. Once I give you an exam, if I screw up, you can't ask me a follow-up. It's there. You have it. So I try to anticipate every way that you can read the question to try and like say, oh, they might read it this way. Let me. So I try to anticipate all the ways that people might read it. And invariably, there are 40 of you. I will miss something, but I do my best. Oh, on the exam. Thank you for reminding me, Amy. At this point, I think you guys are more or less ready to do your midterms. You don't have to, but I think you should. So what I'm going to do is kind of leave things open. You don't have to make an appointment. If you want to go over it, what I want you to do is print out your exam. So please don't email. I can't do 50 attachments. It gets very complicated. Just print it out. Paper's good. And office hours, right? One of office hours right after this class. So we finish, what, at 11, right? I am free usually from 11 till 12. If that doesn't work for you, I'm also free usually around 2 o'clock. I know some of you have class. That's fine. I'm going to try and come out on Friday, this Friday. I'm sorry, not this Friday, but next Friday. I don't know exactly what time, but if you can't come to my office hours, I'll be around on Friday. Now, I prefer if you come office hours because that way I don't have like a long line at the door. But if you have a conflict with class, I'm going to be here next Friday, the 18th. I don't know what time, but it'll probably be in the afternoon at some point. Yeah.
Just a FYI, on that day we have some mandatory meeting at 2.
Of course you do. Well, but you'll be in the building.
Yeah, but just let you know that specific time.
So earlier than 2, people will actually be in the building. Okay, that's actually good. Oh, that's actually useful to know. Thank you. All right, so then I'll check with my property. Is this a 2L thing or a 1L thing? You know?
I think it's a registration thing. 2L.
Oh, I see. Okay, then I'll check with my property students. Maybe they have a different time that'll work. But I'll be here that Friday. You'll be in the building. The meetings aren't going to be long. What I'd like you to do is actually take the midterm from last year under time. Take 90 minutes, go to the library. I'll go over it with you. I'll just point stuff out. If you have any questions, bring those questions. They're helpful. Also, try and just say hi and get to know you. Most of you never come to see me. I've never seen. I've only seen a handful of you outside of class, which I think is a shame. You have professors who actually care about you, and you never come see us. So it's like we feel left out. It's true. Yeah, it's such a strange relationship because like I see you every day for 2 hours on the block. You're in your seat, and then you finish and never see you again. It's a weird thing. And then students who I actually come across, like I had a friend email me. He said, "I'm working with a South Texas lawyer. Do you know him?" Like I don't know him. Then he was in my class 7 years ago. I was like, oh, I guess I do know him. But I didn't remember him because he never came talk to me on anything. I didn't remember the guy's name. And then I looked up my grade. Oh, got an A- in my class. That's great. But I didn't remember him. I had no recollection. So you get to know professors by actually talking to them outside the classroom. You don't. If you don't otherwise, you don't know people. It's unfortunate. But anyway, so I hope you come by, talk to me. We'll chat for a bit. And then we'll maybe make some progress. Okay? All right. Good. Yes. Is that a hand? Oh, no. Oh, no. Okay. But thank you for reminding me. I appreciate that. I meant to mention it, and you reminded me. So thank you for that. All right, let's go on. Let's do Slaughterhouse, first case. Who's up first? I don't remember where I am. All right, Ethan. All right, Ethan, you want to please just start with the facts in Slaughterhouse cases?
Yes, sir.
And by the way, the reason why it's called the Slaughterhouse cases is that there were several cases that were consolidated. They used to do this thing where they would just give it a name, like the civil rights cases or the Slaughterhouse cases or the lottery cases, right? They don't do that anymore. They just don't name cases. I don't know why. Like the Obamacare decision, for a while people said the healthcare cases, and the name just never stuck. Right? It never stuck, so I don't use it. So anyway, this is Slaughterhouse cases. Go on, sir.
So in this case, Louisiana is a legislature passed an act in 1869, and it established basically a privately owned monopoly slaughterhouse in New Orleans. And all the butchers in New Orleans were required to do their slaughtering at this one location.
Yes.
Upon payment of a fee, they had to pay a fee.
Good.
And then the butchers sued Louisiana, arguing that the law was unconstitutional since it violated the Privileges and Immunities Clause.
Okay, very good. Thank you so much for that. Today we take for granted health and safety laws, right? We take them for granted. Has anyone ever worked in a slaughterhouse by chance? Or any sort of a food preparation facility of any kind, restaurant, right? Kitchen. Okay, there we go. Yeah, arms go up. Okay, yeah. There are fairly stringent rules about food safety, right? You have to wear gloves. You have to wear a hairnet. You have to keep temperatures clean. You have to keep instruments clean. You have to keep food at certain temperatures. It can't be too cold. It can't be too hot, right? There's like a bajillion restrictions of how to prepare food, right? With good reason, I think. You don't want people getting sick because of contaminated food or disease, whatever, right? We get this. That's all new, right? That's all a product of the 20th century, really. This case, though, is kind of old. It's in the 1870s, right? 1873. Back then, you didn't really have what you might call health and safety laws. They did not really exist. So Louisiana was trying to do something different. They were trying to do a couple things, but one of the things they were trying to do was to help to increase the healthiness of meat and also prevent disease. Okay, why? This is going to be a little gross, so if you're queasy, just deal with it. When you slaughter an animal, there's a lot of blood that comes out, right? A lot of blood. Where do people usually pour that blood? Well, today they pour it in special drains, right? That's special systems. Back in the 1800s, where would they pour the blood? In the river. They would just dump it in the water. They got to put it somewhere, right? So I just want you to think, you have all this blood and carcass and guts and stuff, and people would pour it on the ground, and they're going to the groundwater. And they pour into the river, and it'll just get really dirty, right? And they pour the guts into the river. You're from New Orleans, right? You're shaking your head. Yeah. There was, and again, I don't want to try and shade your opinion of the case, but there was actually a health crisis, right? You actually had disease, right? You had these rotting corpses, these rotting flesh just sitting around in the street, and rotting flesh attracts rats, cockroaches, right? People get, the plague. I mean, this is not like a trivial thing when you have a very congested city like New Orleans was, by a river, and you have these massive slaughter operations, people just dumping their crap in the street. Okay? So Louisiana had an idea. It's like, okay, here's how we're going to deal with this. We can't have everyone just slaughtering cows and chickens and pigs, whatever else in their backyard, right? We're going to build a single facility. A single facility where people bring their animals to be slaughtered. And that way we can control how the carcasses are disposed of, right? How the blood is disposed of, how the, all the guts and everything else, right? So in other words, it'll be like a railroad, right? You have a monopoly. You bring your product to this one facility. We'll slaughter it for you here, and you get to take your meat, and you leave all the garbage behind. And the city then granted a monopoly to the Crescent City Slaughterhouse Company. Crescent City was New Orleans' nickname, right? Still the nickname today, the Crescent City. So they gave a monopoly to this one company. And this, I only learned this fact recently, but the city didn't have money to actually build it, right? Wouldn't it be great if the city built it themselves? No. What happened was they said, okay, company Crescent City, we'll give you a monopoly if you pay to build a slaughterhouse. So everyone understand what's going on, right? In exchange for getting this monopoly, this company fronted the money to construct this facility, right? That way the city wouldn't have to raise taxes to raise money to actually build the structure. And I think there's a picture of it in your book. It's huge. It was this ginormous facility. I mean, just like is there a picture of it in your book? Yeah. Just what's the page? 817. Yeah. It just imagine it's like this huge long corridor, right? Where basically a cow would come in one side and beef would come on the other side, right? I'm only slightly exaggerating. But it was like this massive operation where all the animals are being brought in. So everyone get the general facts, right? Now, this sounds, oh my God, Josh, this is awesome, right? Who could possibly complain about this? Right, Matthew, who complained about it?
About the law.
Yeah.
The butchers.
Why were the butchers so unhappy with this regime?
Because
Yes, exactly. The effect of granting the monopoly was that local butchers, people who have been in business for, for generations, family businesses, whatever, shut down, right? It was now illegal. It was now illegal to have this sort of operation, right? You could not keep a privately run butcher shop anymore. You had to go to the single government authorized facility. Oh, yes, sir, David.
Isn't there a difference though between a slaughterhouse and a butcher shop? I mean, really at the slaughterhouse, from my experience, all they're doing there is killing the animals. Then after that, it goes to the butcher. So that's
Yes. Yeah. The slaughterhouse, as the name suggests, was actually killing the animal, and then you take the carcass, you slice up somewhere else, right?
right.
So but it's a slaughtering that generates the blood, right?
I think yes and no. It just kind of depends.
I'll take your word for it. I don't know. Don't Google slaughter videos. It's gonna ruin your appetite for a very long time. It's better just not to know. That's how I live with it. Yeah. Yeah. It's just. Anyway, so the local butchers complained. Okay, and they bring this suit. The 14th Amendment was ratified in 1868. They bring this suit, only a couple years after the 14th Amendment was ratified. Okay? Now, Tanner, let me ask you a question. Before the 14th Amendment was ratified, was there any basis at all to challenge this Louisiana law in federal court?
Yes, there was.
Okay.
It was the Civil Rights Act of 1866, right?
Okay. What'd that law say?
It was to protect their trade, right? Because like the right to practice their trade, or at least I believe that was the argument, like that they were trying to.
Okay. You actually answered my question very well. Before the Civil Rights Act of '66, before the Civil War, how about that?
Dang.
You answered my question too well. You jumped a couple questions ahead, so let's start a little bit earlier. Before the Civil War, was there any way of the Louisiana butchers to have gone to federal court about this law? Is there any provision we've studied that might be relevant?
I'm not sure.
Well, Tanner, let me ask you a follow-up. They relied on the Privileges and Immunities Clause, right?
Yeah.
Is there some other provision of the Constitution?
Yeah, that would be Article, I believe it's going to be under Article 4.
Okay. So you have Article 4, Section 2. Right? I know you just needed a hint. Article 4, Section 2, right? The Privileges and Immunities Clause. I want you to separate these two, right? Article 4 is Privileges and Immunities, A and D, right? The 14th Amendment is Privileges or Immunities. How do you remember them? I'll give you my hint, okay? Article 4 comes first. A and the letter A comes first in the alphabet. That's how I remember it, right? The Privileges and Immunities Clause comes first in Article 4. Privileges or immunities come second in the 14th Amendment. Okay, but people screw this up all the time. Justices screw this up. It drives me bananas, but that's where we are. Okay, so Natalia, let's talk about the Article 4, Section 2 a bit. It says, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Could the butchers have relied on this provision to go to federal court? Let's say Louisiana enacted this law before the Civil War. Could they have relied on this clause to go to court?
Yes,
You say yes. Why?
because they're citizens of the state of Louisiana. And I don't know, because I guess I'm just.
What did the Article 4 Privileges and Immunities Clause do? We've talked about this in a few cases so far. We've talked about it in Dred Scott. Right? Think of the black sailors we talked about. Remember that discussion?
Yeah.
So what was that about? Remember they went from South Carolina down to Boston, or South Carolina down. They started in Boston and went to South Carolina. What was this provision discussion?
That they were not, that African Americans were not citizens.
What does this clause actually do? Does this guarantee rights to citizens of a state?
Yes.
No. David?
No, it doesn't.
What does this
Yeah,
clause actually do?
All this clause does is give the citizens in the state entitlement to the rights that state offers to that citizen.
Yes. So, for example, if you were a citizen of South Carolina and then I travel from Boston and I'm a citizen, I get whatever right a South Carolinian gets, right? This was a non-discrimination provision. In other words, whatever rights Louisiana gave to its own people, it will then have to give to the citizen of Texas who travels there, right? If you were traveling from Texas to Louisiana, Louisiana must give you the same rights it gives to its own people. Now, Natalia, let me come back to you just for one follow-up. Did the Louisiana slaughterhouse law discriminate against foreigners?
No,
How did it treat its own people?
it discriminated against them.
Bingo. The right was denied to its own citizens. Exactly. Louisiana denied the right to its own citizens, right? No one can build a slaughterhouse, not from New Orleans, not from anywhere else. It was a blanket prohibition. So the Article 4 Privileges and Immunities Clause would not have helped the butchers. But the 14th Amendment, they argued, changes the game, right? Nolan, help me out here. What was the argument that the 14th Amendment's Privileges or Immunities Clause helped the butchers out? What's the argument, sir?
That the 14th Amendment secured their natural rights, their civil rights.
What did they understand the phrase privilege or immunities to include? Let's be precise here, just exactly what they were talking about.
Was it to include the rights given to them by the Constitution?
Well, be more precise. You're right, but just be a little more precise, please. What exactly was the right they were asserting? What did they want, Nick? Sorry, not Nick's next. Be on deck. But Nolan, what did they actually want? What were they actually asking for?
Right to practice their trade.
Bingo! That's it. Yeah. They argued that the Privileges or Immunities Clause, that this phrase privileges or immunities, included the right to practice their trade, or the right to pursue a calling, you might see, right? Or you might see the right to earn an honest living. You can phrase it in different ways, right? But they wanted the right to practice their trade. They were butchers. That was their trade. They've been butchers for a very long time. And they argued New Orleans did not have the power, did not have the police power to deprive them of their rights. Or let's just use it here. No state shall make or enforce any law which shall abridge means violate, which shall abridge the privileges or immunities of citizens of the United States. The butchers argued that this phrase privileges or immunities refers to an old set of rights, this well understood body of rights. And a state could not violate those privileges or immunities of citizenship. Okay? Everyone with me so far? But look, the Constitution does not define privileges or immunities. Doesn't say what they are. So Nick, my question for you, how is a court supposed to know what these privileges or immunities might be? I mean, this is, again, we're only a couple years after the damn thing was ratified. This is people who were alive and well, right? They knew what happened. How's a court to know what a privilege or immunity is?
This court looks at the reason why the amendment was passed in the first place.
Okay. Well, you're right. I want to get there in a minute. You're just a little bit ahead of me. Why do the butchers think, or what do the butchers look to argue that the right to earn a living is a privilege or immunity. You're right about what the court does, but I'm talking about the butchers first. Where do the butchers get this from? That this right is this right to earn a living is a privilege or immunity. Where do they get this from?
Is it the
Tanner said it a minute ago. You were ahead of the game. Where do they get this from? You said it. You're listening? You said it.
I was more focused on the answer that you provided.
Tanner, what'd you say?
It was the Rights Act of 1866.
Civil Rights Act of 1866. And what did the Civil Rights Act of 66 say? You're right.
What did it say?
Yeah, what did it guarantee?
It guaranteed the right to practice their trade, right?
Close enough. Okay. You're in the ballpark. Okay. The Civil Rights Act of 66 was passed in 1866, right? And if you recall, Congress enacted it based on the 13th Amendment, right? Based on the 13th Amendment. And they wrote this in part to grant certain rights to the freedmen. But again, the language was not limited to the freedmen. It applied broadly to people, not just the freedmen, to people. And I'm going to read you some of the things it protected. It protected, number one, the right to make and enforce contracts. Number two, the right to sue, be parties and give evidence. Number three, the right to inherit, purchase, lease, sell, hold, and convey property. 4, the right to full and equal benefit of all laws and proceedings with the security of person and property. Now, I didn't mention the right to earn an honest living or the right to pursue a calling or the right to pursue a trade. Tanner, you want to say something?
Yeah. It was like getting unenumerated. So.
What does unenumerated mean? You're jumping a little bit, but I'll go for it.
It isn't expressed, but it can be implied.
Right. The phrase unenumerated means not written down, and we'll see a lot of cases this semester with unenumerated rights. This is one of the first ones. There is no express document saying that you have the right to practice trade as a butcher. That's not written anywhere. But it was something that people understood, right? The butchers understood they had this right. Myra Bradwell, the lawyer, understood she had this right. Where did they get this from? Were they just making crap up? No, there was a very, I think at least at this point, a very well understood body of law that said you have the right to practice your trade. And these were privileges or immunities of citizenship. All right, so the butchers go to court and they argue that the correct meaning, all right, here's a little graphic we have from the video, right? That the correct meaning of privileges or immunities were these old rights, among which are the right to earn an honest living, right? And again, both the butchers and Bradwell thought this was the correct reading of the 14th Amendment. They weren't like on their own. They legitimately thought this was the best way to read privileges or immunities. All right, first, let me ask you a question. If the butchers were right, and if Myra Bradwell was correct, would this significantly change the way states can legislate? If the butchers were right, would this really change the state's police power?
Not going to courts.
Well, no, the court thinks they're wrong, but just assume for a minute with me that the butchers were right. Would the butchers' interpretation of the 14th Amendment radically change the state's police power?
Yes.
Yeah, you're right. Tell me why.
Because it would, I'm sorry, could you repeat exactly what?
Would the butchers' understanding of the 14th Amendment radically change the way the state can exercise its police power?
Yes, because it would severely limit it.
Well, yes, why would it severely limit the state's police power?
Because it would
Yes. And what happens if they enact such a law? What would the people do?
They would basically challenge it.
Where?
In the Supreme Court.
In court. And one more question. You're almost done. Before the 14th Amendment, were any of these cases ever going to federal court?
No.
No. Okay, that's your answer, right? If the butchers were correct, it would radically alter the way states can exercise their police power. Right? Before the Civil War, the states could basically do whatever they wanted. Right? They could enact whatever kind of police power law they wanted. But if the butchers are right, if Myra Bradwell is right, then any time a state runs afoul of one of these privileges or immunities, the right to earn a living, they go to court. And then a court come in and say, no, you can't do that. That's unconstitutional, right? You are violating their rights. We, a court, are telling you that you can't enact this health and safety law. Everyone see that? Hang on, let me ask you a question. Do you think the Supreme Court was, or the majority at least, was like, wanted that sort of change in which the courts would be involved so much? Why not?
Possibly to hold on to that broad power that they currently have,
Who's they?
or like the police power.
Right, so were the justices of the majority willing to accept this new understanding of the 14th Amendment?
No.
Why not?
Possibly because they didn't want to allow other people to come into court.
Yes.
Regarding the same issue.
Yeah, there's one line in the opinion where the majority says, we don't want to be a censor, right? We don't want to be a perpetual censor of state legislation. What does that mean? We don't want to be in the position where people come to court every 5 minutes with another state law. This violates a privilege, and that violates a privilege, and this violates a privilege, right? Right? Like, we don't want to do this, right? We are not going to be involved of reviewing every single state police power law. Yes, sir?
I might be jumping ahead, but if Chief Chase had in better health that day, it could have been that way.
The vote, it wasn't terribly close, but a couple of votes here or there could have made a difference. I don't know if Justice Field was in better health. Could the case come out 5-4 the other way? I don't know. But let me just give you a. Who asked about the fringe theory the other day? Who was that? Yeah, that was you. Yeah. This is actually not insane. So I think you asked me the other day. Was the 14th Amendment properly ratified? Right. A lot of the states were sort of twisting their arms to get them to ratify it. There was a non-trivial possibility that the court would have declared the 14th Amendment unconstitutional. Right? There was a non-trivial argument that the court could have said in Slaughterhouse, this was not properly ratified. We're not going to abide by it. Can you imagine what would have happened? So in some sense, it wasn't that bad, right? It could have been much worse, right? The court could have said, never mind, 14th Amendment, you're off the books. Not properly ratified. So it was as bad as it could have been. The court upheld it. But to avoid giving this censorship power, where the courts were involved in every single case, they did something very deliberate, right? Antoine, what did the court do to avoid injecting itself into every conceivable, state police power matter?
I think the majority opinion started to make distinctions between the rights afforded to U.S. citizens and then the rights afforded to state citizens. And so they started making distinctions to like habeas corpus, being able to transit across waters.
Okay. You're giving me. Let me just reframe you a bit, right? The butchers argue that this phrase "privileges or immunities" refers to these old common law rights, like the right to earn a living, right to own property. How does the majority, Justice Miller, how does the majority interpret the phrase "privileges or immunities"? What do they look to?
Isn't it that they solely just look at privileges or immunities solely to the United States citizens?
Yes, exactly. Okay, thank you. The majority rejects the butchers, right? They reject the butchers' reading. Instead, they pick a different reading. what are the privileges or immunities of citizens of the United States? That is, what are federal rights? What are federal rights? That is, rights that are tied to citizenship in the United States, not rights that are tied to state citizenship. Let me say that one more time. The majority rules that this provision does not protect rights associated with state citizenship, like the right to earn a living. Instead, this provision concerns rights associated with U.S. or federal citizenship. Everyone with me? And Antoine, you gave me some, but what they list a couple. They're kind of like silly, but just list them for us, please.
The national or the state?
The national rights, please.
So like habeas corpus, being able to transit high seas, any kind of like protections given to U.S. citizens in foreign nations,
Yeah.
afforded only because of their U.S. citizenship, not their state citizenship.
Thank you. Okay, so Justice Miller lists a couple. I'm going to read them to you because I think they're important to have in your notes. The right to come to the seat of government to assert a claim. The right to engage, the right to free access to seaports, basically going to harbors. The right to access sub-treasuries. Access to courts of justice. You can demand care and protection on the high seas. You can petition for habeas corpus. You can use navigable waterways of the United States. That's about it. If I look underwhelmed, I am. What this basically means is a state police power was altered only minimally by the 14th Amendment. That the states can basically do whatever they want so long as they don't prevent you from traveling on the high seas. Okay. That the state can't pass a law that blocks your access to a federal treasury. Okay. That the state can't pass a law that prevents you from accessing the federal capitol in Washington. Okay. All right, that's it, right? The right to earn a living was not one of these rights. Now, I have to ask Martin, how does a court come up with this list of rights that you know, we just fought a bloody, bloody, bloody civil war, you know, thousands were killed, slavery eradicated, we have these radical Republicans in Congress enacting this provision of the Constitution. How do we get this list of rights? Where on earth does this come from, my friend? Where does this come from?
Would it be kind of like the public health concern? I'm not
No, but you're giving me why they did it, but where does this list come from? Like, where do they get this list from? Where on earth? I just listed about 5 or 6 things. Where do they get this list from? You're struggling.
Yes, I am.
Anton, want to take another step?
That was the Crandall versus Nevada.
It was a case called Crandall, which I don't know what the hell the case is about, right? But I want to torture Martin just for one more minute. Does the court look at the Civil Rights Act of '66 as a possible, this was when Tanner mentioned a couple minutes ago, as a possible ground for interpreting this provision?
I think they did, but I'm probably wrong.
They don't really think it's very relevant. Yeah. So, look, I mean, here's the history, right? We have this Civil War. We have this 13th Amendment. We have this Civil Rights Act of '66, which was this major legislation. And the court basically says, no, we're not going to do that, right? We're not going to look to this. Okay? But we have the Civil Rights Act of '66. And the court says something that is very significant. They say, the Civil Rights Act of 66 doesn't really apply here. Well, right? Why? Well, that law was about denying rights to people based on their color or race. And the butchers here are not being segregated against. They're not being discriminated against. So it doesn't apply. But the relevance of that act was not the racial component, but was a definition of the rights protected by it. Right? So the court had to give a very cramped and narrow reading of a lot of provisions of law to avoid becoming a perpetual censor on state legislation. That is, if the words of the 14th Amendment were taken seriously, the states now could not do what they did before. And in theory, at least, the courts would come in and declare those actions unlawful. But that was not meant to be. And the slaughterhouse majority slammed the door shut on the 14th Amendment. And if you want, these are the rights that were listed: the right to assert claims in the government, right to access seaports, protection of the high seas, use of navigable waters. And these are a fairly insignificant listing of rights. And okay, accessing rivers, I guess, is important. You got to get around, navigate. These are not very important. To this day, my friends, the Privileges or Immunities Clause is a dead letter. It just doesn't have any resonance in constitutional litigation. It just doesn't matter because they defined it so narrowly in 1873. Okay. Oh, yes, sir, go ahead.
Didn't they also, in the majority, say that the butchers weren't technically being denied their right to practice their trade, but they were actually just told to come to this other facility?
Well, that's a question on what you might call reasonableness, right? Were they actually denied their trade? But it didn't matter, did it, for the majority, because the right didn't exist in the first place. In other words, had Louisiana simply banned butchering altogether, that would not have violated the federal constitution. So it didn't really matter. Okay? Yes, sir, Nolan.
So, the 13th, 14th, and 15th Amendment came right after the Civil War. How does the majority come to the conclusion that these were the rights that privileges or immunities clause was trying to protect? Because obviously, the Civil War wasn't fought over the right to water.
Yeah, I mean, I have my notes, and there's an expletive, so I'll just bleep it out and say, the Civil War fought over the right to effing sub-treasuries. That's why I have my notes. Okay, I guess that's right. No, I know, it diminishes it, but that goes back to the question we have today, right? At the poll. Was this intended to only protect the freedmen? Right? If the goal is only to free the freedmen, then slaughterhouse isn't wrong. Right? They weren't denying the right to butchering just to white people or black people. They were denying it to everyone. So if you read a very narrow intent of the 14th Amendment, then slaughterhouse isn't necessarily wrong. But if you look at the words that were chosen, the meaning of those words, then it's unquestionably incorrect. Make sense? Okay. Any other questions in the slaughterhouse majority? I think, Ruben, you're next. Ruben, you want to give me the dissent? I think Justice Fields' the first dissent.
Yeah, he basically said that the privileges and immunities clause was protected by pre-existing fundamental rights.
And how does Field know this? How does he know that there are these sorts of how does Field know that the privileges or immunities clause protects these old pre-existing rights? How does he know that?
I think he references Corfield.
Corfield v. Coriolis. Let's talk about that for a minute. Yeah, what's that case about?
Basically established the rights that he's referring to, the right to possess property of every kind, pursue and obtain happiness and safety, subject to restraints for the general good of the whole.
Yeah. All right, so let me just mention for a minute, it's Corfield, not Cornfield. In I was so mad. In one of the earlier drafts of the book, I wrote cornfield, and the student noticed, and I was just livid. So it's not cornfield, it's Corfield. Please don't make. I was embarrassed. Corfield versus Coryell was a decision from the Circuit Court. It was not a Supreme Court decision; it was a lower court decision. And it was written by Justice Bushrod Washington, who was George Washington's nephew. A wonderful name, Bushrod. And he was interpreting the. I like it. He was interpreting the Privileges and Immunities Clause in Article 4. The Privileges and Immunities Clause in Article 4. And he provided a very early definition of Corfield v. Coryell, right? What were these rights? For example, the right to own property, right? The right to convey property, the right to pursue and obtain happiness and safety. He understood the rights to be the same sorts of rights protected in the Civil Rights Act of 1866. In other words, the same sorts of rights that Congress protected in 1866, Justice Washington wrote about in Corfield v. Coryell. Not exactly, but in the same ballpark. Many of the people who were involved in drafting the 14th Amendment seemed to embrace Justice Washington's opinion. And in fact, they were reading from Corfield v. Coryell on the floor of the Congress. Not everyone agrees with us on this. There are people who disagree, so I'll let you know there's debate, but this is a position that Randy and I usually fall on. So Justice Field says, look, we have this Corfield v. Coryell, right? This is not about federal citizenship. This is about the sort of pre-existing rights that we have. And that this provision limits what states can do. Okay? Anyway, all right. So any questions on the Field dissent? Right, so when you want to look at the Field opinion, this one sort of helps. He argued that the Article 4 privileges and immunities from Corfield and the Civil Rights Act of '66 were part of it. Okay, I think, Jessica, I think you're next. What did Justice Bradley say?
So Bradley basically said that protecting fundamental rights would jeopardize federalism.
Why?
He said that states could reasonably regulate the exercise of fundamental rights as long as it didn't suppress the exercise of those rights.
All right, let's just take a step back. If, in fact, the butchers were correct, the states are now in trouble, right? The states now have to deal with a situation where all their laws can be challenged in federal court, and that's new, right? As states try to enact health and safety measures, police power laws, they may be dragged into court. So I think you have to recognize that even if even if the slaughterhouse dissenters were correct, this would radically change how the states can operate. But it also gives not just the courts power, it gives Congress power. Recall that Congress has what's called Section 5 powers. Section 5 powers. If a state is violating privileges or immunities, Congress can come in and enact laws to limit the state's powers. And we know that state laws, when they're in conflict with federal laws, the state law prevails. That's the supremacy clause. So now, basically, Congress has a power to control the states in new ways. And that's, I think, a legitimate fear of what might happen. And Justice Bradley writes about this. Okay? All right. I think we did enough on Slaughterhouse. Anything else on Slaughterhouse? Anything on Slaughterhouse? Okay, let's move on. Slaughterhouse was decided, and this was the first major interpretation of the Privileges or Immunities Clause. The very next day, we have the case of Myra Bradwell. Now, Ms. Bradwell had the unfortunate disadvantage of timing, right? Her case was decided the very next day after Slaughterhouse. Usually when the Supreme Court decides a case that implicates another case, they send back the second case to the lower courts to reconsider it. It's like, well, we just decided Slaughterhouse. Do you want to, maybe replead your case? You want to change it up? She did not get that advantage. All right, so Katie, why don't you give the facts, please, in Bradwell?
Myra Bradwell was married to a prominent lawyer in the 1870s.
Uh-huh.
Later on was a judge, and he taught her, I guess, the law, basically how to practice law.
Yeah, let me just interrupt you for a minute. Law schools are a fairly recent phenomenon. Until the 20th century, the primary method that someone became a lawyer was called apprenticeship, right? Where you would basically read law, so they call it reading law, where you would work under a lawyer for X number of years, and eventually you'd be allowed to sit for the bar, right? There wasn't an exam, it was basically like an admission. Does anyone know the most famous person currently reading law in the world? Yes, just say it. Just say it. Kim Kardashian. She is, under California law, reading law with an attorney, and she actually wants to be an attorney. And do you know whose contract book she uses? Randy's. She put on Instagram a picture of Randy Barnett's contract case book. Of course not our book. That'd be too easy. That'd be like the best marketing ever. Like millions of people. Of course not. But she Instagrammed a picture of his case book. So anyway, he was very excited about that. He's like, I'd love to help you with contracts sometime, Kim. Yeah, no response. Oh boy. Oh God. Okay, got a Kardashian reference. The semester's done. Okay. But anyway, all right. So she was reading law. Now, Katie, go on. Keep going with the facts. Lord help us.
So then she applied to the. Started on Kim Kardashian.
Yeah, I'm sorry.
She got 100 on her torts test.
Oh yeah. Yes, she did. Yeah.
Okay, so she applied, and they basically told her no. The Supreme Court of Illinois told her no, or her application was told her no under the laws of coverture, which I understood as being like that she was a woman, she was timid, that she was unfit to, basically because she was married, she couldn't sign the contracts that a client and an attorney would need to sign or have, and then also that she needed to be at home protected by her husband, and that practicing law isn't a right, right like that is supported by her.
Okay, very good. Thank you. I think you a lot of good things. Let me just unpack this one at a time. So the first thing is, at this time, there wasn't really law school, right? The only way to become an attorney was to have this sort of apprenticeship, the reading law. And her husband was okay with this. He actually allowed her to work in his practice and do all the things that were needed to be an apprentice. She then sought admission from the Illinois Supreme Court, right? It wasn't like today where you just apply and you do an exam. You would actually have to go to the Supreme Court and apply for admission. That's how it would operate. The Illinois Supreme Court said, no, we are denying you application. And the rationale had to do with the law of coverture, which Katie mentioned a moment ago. I'm sure you studied coverture and property. Sound familiar? Okay, you'll get there. Okay. I can preview it. Coverture, think of the word cover, right? At common law, if you were a single woman, you were allowed to own property, you were allowed to make contracts, you were allowed to do all these sorts of things. However, when a woman got married to a man, the woman basically ceased to exist, right? The law created a fiction, the married entity, right? Husband and wife. Any property that the woman had was deposited in this entity. Any property the man had was deposited in this entity, right? You say, oh, that sounds fair, Josh. Well, under the rules, only the man could manage the property, right? He could make the contracts, he could sell, he can lease, he could buy, right? So effectively, a married woman quite literally ceased to exist, had no independent legal status. And the Illinois Supreme Court said that a married woman could not be an attorney because of coverture, right? An attorney has to make contracts with a client, has to keep client property, and a woman cannot do any of these things. that was a rationale for the Illinois courts to make their decision. Okay. Then Bradwell goes to the U.S. Supreme Court and she says, aha, this state is violating the 14th Amendment. That the right to admission to the bar is a privilege or immunity of citizenship. Again, it doesn't say men. It says privilege or immunity of citizens, and she was a citizen of the United States. She was born here. So she goes and argues to the Supreme Court, says privileges or immunities. Now, again, she argued the case before Slaughterhouse was argued, right? Or decided, I should say. Had she known that Slaughterhouse would go that way, she maybe made a different argument, but she didn't have that advantage. All right. So Leslie, help me out here. How does the court handle Ms. Bradwell's claim?
They said that it wasn't protected by the privileges and immunities clause because it didn't depend on citizenship.
Yeah, very good. After Slaughterhouse, this was not a very hard case, right? Right? Slaughterhouse was 5-4. And Slaughterhouse, the majority said that the privileges or immunities clause only protected a very narrow set of federal rights, such as the right to access to sub-treasuries and the protection of the high seas and these sorts of silly things, right? Okay. But the votes in Slaughterhouse didn't line up with the votes in Bradwell. The only dissenter was Chief Justice Salmon Chase, who at this time was quite ill. You had Field, Bradley, and Swain had to, explain themselves. Why? Well, they ruled that the butchers have this right to practice their trade. But then what about Ms. Bradwell, who wanted to be a lawyer? Colby, how does at least these three guys reconcile their votes from literally the day before in Slaughterhouse? How do they reconcile their votes? That was the entire. What did Justice Bradley write about in Bradwell? Do you do the reading?
In Bradwell, Bradley?
Yeah. What did Bradley write in Bradwell?
Oh, you're asking me.
Yes.
Basically saying that that women are dependent upon men, and that women's priority is to be wives and caregivers.
Yeah.
And that they don't have a right to be, I guess, in this case, attorneys or have a license.
Yeah. Very good. Thank you. Basically, Justice Bradley writes concurrence, this is Bradley. It's run by Justice Field and Justice Swain, and they have to explain, why are the butchers in Slaughterhouse different from Bradwell the lawyer? It speaks for itself quite literally. One second. Man is woman's protector and defender. The natural and proper timidity and delicacy of the female sex makes them unfit for any occupations of civil life. This one. The paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother. This is the law of the Creator. And the rules of civil society must be adapted to the general constitution of things and cannot be based on exceptional cases. We give the heartiest concurrence to humane movement of modern society and the multiplication of avenues for women's development, but we're not prepared to say this is a fundamental right and privilege, especially for a job with high qualifications. It's for the police to decide. Okay. I mean, it's gratuitous. There's no reason to write this. He could have just said nothing at all. But he felt compelled to explain himself of why he went one way in Slaughterhouse and the other way in Bradwell. And you know, sometimes when you say something, you say too much with your foot in your mouth. This is one of those, and this is one of those opinions that, like, you know, 150 years later, you're still like, wow, right? Yeah, Suresh, I think your hand was up a minute ago. You sure? Okay. Chief Justice Chase dissented, but regrettably, he didn't write a dissent. And this is one of those cases where I think the absence of a dissent was unfortunate. We'll have a couple of cases like this semester where there's a really like lopsided decision, like an 8-1 decision, and there's no written dissent. And I think the written dissent is helpful because it shows that at that time there was at least someone in a position of that power who understood that the majority wasn't doing the right thing. So like in Dred Scott, you had Justice Curtis, right? Who's the other one? I'm blanking the other one. But you had two dissenters in Dred Scott, right? Here you have Justice Chase, who was silent. And the reason why he was silent is because of his health. He died, I think, barely a month later. He had a stroke. And you know, he was not able to actually express his opinion. But Chase was, I mean, put some of these quotes in the book, was fairly progressive. He favored women's rights. He was the abolitionist attorney general for runaway slaves. And he probably could have written something a little bit more cogent than Justice Bradley wrote, I think, at least. I don't know. All right. Questions on Bradwell? Questions on, yes, sir. Ray. It's a very good question, and I get this one I think almost every other year or so. I don't know. They may have some other reason to deny her admission, right? The Coverture thing seemed like a very, I don't want to say correct, but the Coverture argument was actually like non-trivial, right? There was actually a legal impediment for married women to make contracts. But had she been single, that argument would not have been present. I'm sure they could have found some other reason to deny her. Her character wasn't fit. You know, they could have made something up. So I'm not optimistic. But the story kind of turns out better, right? Bradwell never applied for readmission. Instead, she became a journalist. Nearly 20 years later, in 1890, the Illinois Supreme Court reversed itself, and they admitted her. Again, she didn't actually apply. They just reconsidered her decision. It's like, whoops, we screwed up, guys. And in 1892, the Supreme Court of the United States admitted Bradwell to the bar. So 20 years after Bradwell was decided, she was admitted to the Supreme Court bar, and the Attorney General actually moved for her admission, which is kind of cool. So, you know, doesn't quite overrule the decision, but the court recognized that she had a member fit for the bar. Okay. Let me just make a brief note. Bradwell only made an argument based on the Privileges or Immunities Clause. She did not make an argument based on the Equal Protection Clause. In about 2-3 weeks, we'll study the court's Equal Protection Clause cases. And they're cases involving sex discrimination. The modern sex discrimination cases are not based on privileges or immunities. They're based on the Equal Protection Clause. And the argument goes like this, that the state needs a really good reason to discriminate between men and women, right? They need a very good reason to treat men one way and women another way. And there are a bunch of cases in the 1970s and 1990s as well that articulate this perspective. Bradwell was never actually overruled, as bizarre as that sounds, but the modern cases have gone on a different clause. Yes, sir. Suresh.
Would those cases be argued by Chief Justice Ginsburg?
Yes, in fact. There were two cases, or one of them argued, called Frontier versus Richardson, and Craig versus Boren, and Ginsburg argued at least one of them, if not the other one. She argued Frontiero. There was a movie on the basis of sex. Did anyone see it? I didn't like it, but anyway, I'm very picky. But it's a movie about Ruth Ginsburg's life, and it includes some of her arguments in the Supreme Court. Too many Ginsburg movies. I saw one. I was like, okay, I'm good. Fun fact: if you ever watched the Ruth Ginsburg confirmation hearing, Joe Biden was presiding, and sitting behind her was Elena Kagan, who was Biden's chief counsel. The world is flat. Just the same people keep recycling different scenes. It's like, oh, there's Kagan. Just sitting behind Biden. during Ruth Ginsburg's confirmation hearing. Just the world's flat. Okay. All right, other questions so far? All right, let's go on to the last case for today, which is United States against Cruikshank. And let's just do a little review. Jason, do you remember the holding in Barron against Baltimore? Barron v. Baltimore. You can look up your notes if you need.
I don't know.
You can look up your notes if you need. What? No, you can look in your notes.
Okay.
Barron v. Baltimore. For the first week of class. Oh, you can't control it if you have paper notes, I see. Barron v. Baltimore. By the way, by the time you get to the final exam, you should know every case name by heart, more or less, right? Or at least know the facts of the cases. Yeah. If I say, what's Barron, you should know what the answer to that question is. The case names are very important. The reason why is when you actually write your midterm, you should be discussing cases and actually incorporating cases into your answer. Don't just give me rules, give me cases. Yes, sir?
Yeah, is it the water, the sand?
Yeah, water, sand, and Baltimore. Good. What was the holding of that case, sir?
They say no, they didn't
What's it?
violate whatever.
No, it's in violate whatever. You gotta give me better than that.
I don't remember. I really don't remember. The court hold, I can't read your handwriting.
So just read it. Just move. Put it out of his misery.
The court held that the takings clause of the Fifth Amendment was not violated by the city of Baltimore.
Okay, thank you. Right. Jason, I didn't mean to be picking you. I was trying to actually make a point here. And we're all friends here. But when you have your exam at some point later this semester, you're going to need to do some things, right? You're going to get a fact pattern. And the facts are going to be similar to a case you've read, but different, right? Where I'll take the facts and I'll twist it a little bit. You need to say, oh, this is like X v Y, but different. Or this is different than X v Y because of this reason, right? That's what I'm looking for. But you need to know what X v Y is, right? Having a 50-page outline will not help you because it won't give you the answer. You need to, oh, this is like Barron, or this is like Gibbons, or this is like McCulloch, or this is like Hepburn versus Griswold, right? Or this is like Knox v. Lee, right? I know I'm saying names that you don't probably remember, but you need to actually learn these. You need to be conversant, fluent in constitutional law. Like the same way you would say negligence or libel per se. You say, oh, Barron v. Baltimore, right? These are legal concepts that lawyers need to know for constitutional law. If you give me an answer and you don't talk about cases, you're getting a C, right? I'm not being facetious. The way you get yourself to a B and an A is by incorporating cases into your answer and understanding what these cases said and what they didn't say. Okay, so I really didn't mean to pick on Jason, but I was trying to make a little point. And well, you kind of cheated. So I mean, that's more like an expulsion. But no, it's okay. We're all friends here. I appreciate the offer to help, but just don't do that in the exam. That's one way to get it. People do cheat on exams. I know it's shocking. I've had situations where people leave stuff in the men's room. Like they'll hide like a note card in the toilet paper roll in the men's room. Like it's insane. You're wasting so much time. You're risking getting caught. They go to the stall and they leave like a little note card or something in the stall. I can't fathom how dumb you have to be to do that. It's just it boggles, but it happens. I know it happens because people get caught. Right? The school actually sweeps bathrooms beforehand. The school sweeps the classroom. We've had people who tape stuff under the desk right over there. They'll tape a thing. I'm not making this up. People come to the classroom hours before and they know where they're going to sit. They tape something under the desk. Look, that's why on exam week now we actually lock down the classrooms for hours in advance so people can't do that. They can't tamper with. You ever wonder why the rooms are all locked during finals week? Because people can come in, they hide stuff under their desk. They put a little note card, they put it under their chair, whatever. which is why my exam's open book. Bring whatever the hell you want. It won't matter, right? Which, yes, hide something in the bathroom that you can bring with you here. It's just it won't matter, right? That's why I don't care what you bring. It's not going to help you. But people, on closed book exams, people find ways of cheating. They go to the bathroom. They put stuff in the stall. They talk to the guy next in the stalls. I can't explain why people do this. It's so pathetic. But if you get caught, you get thrown out. That's a letter to the bar. I mean, character and fit. You know about the character and fitness? Tell you about this stuff. Like you can screw up my exam, but like okay, he made an honest mistake. But if it's a not honest mistake, that goes to the bar. That goes to the state. And that's stuff that it's really hard to get away from. It's like the weird thing. If you're a bank robber, you have a higher chance of getting to the bar if you're a bank robber than if you wrote a bad check. Because one's a crime of honesty, the other's a crime of violence. Crimes of violence, okay, at least you're honest about it, right? I'm only being slightly facetious, but like if you engage like some sort of white collar offense versus being a bank robber, like the bank robber is probably less of an honesty sort of crime that'll let you in. Well, I'm only being slightly facetious, but it's true. So don't rob banks, please. Anyway, a friend of mine, you maybe know the name, Sean Hopwood. Do you know the name? Sean Hopwood is now a professor at Georgetown, but he spent about 8 years in federal prison for robbing a bank. He has a remarkable story of redemption. While he was in prison, he was a jailhouse lawyer. He wasn't actually a lawyer, but he filed papers for people. And he had 2 cases granted to the Supreme Court while he was in jail. He didn't even barely graduate high school. And now he's a law professor at Georgetown. He's a very good friend of mine. And but it happens. But anyway, don't cheat in exams, please. Just please don't hide a stupid note card in the toilet paper roll. Just don't do it. I don't know why. It's dumb. It's so dumb. Anyway, okay. Back to where we're at now today. Barron v. Baltimore. First week of class we did. You had the city of Baltimore, which did some construction, which messed up Mr. Barron's wharf, his dock. It basically made it the water was too shallow. They couldn't put any boats in there. He argued that the I don't have it here, but he argued that the taking of property. He argued that the city took his property without paying compensation. What did Chief Justice Marshall hold? Chief Justice Marshall held, no. The Bill of Rights, the first 8 amendments, only limit federal power. They don't limit state power. Congress has to pay compensation, but the states do not. And Marshall said, look, if you're not happy with your state law, change your state law, but you don't have to change your state constitution. All right? You cannot give the federal constitution supremacy over the states like that. Now, the question is this. Did the 14th Amendment reverse Barron? Did the 14th Amendment change the structure? Did the 14th Amendment extend the Bill of Rights to the states? Right? To use the lingo, did the 14th Amendment incorporate? The phrase we use is incorporate the Bill of Rights. Did the 14th Amendment make the states subject to the Bill of Rights? Okay. Now, Slaughterhouse and Bradwell involved unenumerated rights. Who said that one? Was it Tanner? Yeah. Thank you, sir. Slaughterhouse and Bradwell involved unenumerated rights, as rights that are not written down. Cruikshank was the opposite. Cruikshank involved enumerated rights. Cruikshank involved enumerated rights. That is, rights that were written down where? In the First and Second Amendments. Okay? Cruikshank presented the question of whether the 14th Amendment's Privileges or Immunities Clause included the Bill of Rights. That is, were the First and Second Amendment privileges or immunities of citizens of the United States? If the First and Second Amendment were privileges and immunities of citizens, then the states could not violate them. Okay? So we can understand Slaughterhouse and Bradwell as the court being cautious, right? They say, look, we're dealing with this phrase, privileges and immunities. We don't know what it means, right? We don't want to deal with these unenumerated rights. People are making stuff up. So we're going to be cautious. But Deanna, what was the question then in Cruikshank, right? Was it a similar question that of rights that are not written down?
No, it wasn't. They were enumerated.
Yeah. So Cruikshank is a lot harder to justify than Slaughterhouse. I mean, I think Slaughterhouse is wrong, but I can get why they did it. Cruikshank's a lot tougher to justify because these rights were written down. And during the ratification debates in the Congress of the 14th Amendment, members of Congress would read the first 8 amendments as privileges and immunities. Not all of them, but most of them. The right to freedom of exercise, the right to freedom of speech, right, the right to keep and bear arms, right, protection against search and seizures, right? These were rights that were deeply held, that were written in the Constitution. So people today don't always agree on Slaughterhouse. There's some dissent. But I think almost everyone agrees that Cruikshank is wrong, right? Some people say Slaughterhouse was right. I'm not going to get into the fight now. But almost everyone thinks that Cruikshank was wrong. And that's why Justice Thomas voted to overrule it in 2010. We have one other data point. If you remember in Dred Scott, Chief Justice Taney had this one line where he said, wait a minute, black people can't be citizens because then they get the privileges and immunities, including the right to bear arms and the right to peaceably assemble. Even Taney recognized that the First and Second Amendments were privileges and immunity. Even Taney, who had a very narrow view of rights. Right? Okay, but alas, one more time, the court narrowly read privileges and immunities. Any questions so far? Vanessa, you want to please give me the facts in Cruikshank? And the facts here are gruesome. You know, again, this is not like the South Dakota lose 2% of its highway fund. No one actually cares about that, right? These are the facts, please.
So there was a Republican faction of Americans that seized a courthouse in Colfax.
Yeah, anyone from Colfax, Louisiana, know what that is? It's, you know, it's not too far from New Orleans. Okay, go ahead, please.
And they were armed with rifles.
Yeah, and just to let me give you a little bit of background. A lot of these people were former soldiers in the Civil War. And basically, after the Civil War ended, these people kept their weapons. That's the way it worked. And at the time, there was a lot of political violence. And these freedmen used their weapons as self-defense to prevent themselves from being lynched by the mob. All right, go on, Vanessa.
So about 3 miles east of Colfax, a black man was killed in front of his family, and so that kind of started an uprising.
Yeah.
And more than it says more than 400 armed militiamen came to the courthouse.
Yeah.
And
Because they thought they won the election, right? There was a disputed election. And they said, this is our election, we are in charge. And they basically tried to occupy the courthouse. Oh, go ahead.
so in response, a group of 150 white people came and attacked the courthouse.
Yeah, these were the Democrats, the other side who lost the election. Yeah, go on.
And they basically set the courthouse on fire
Yeah.
to smoke them out.
Yeah, to burn them alive.
Yeah.
Yeah.
About the Republicans were fleeing and they surrendered, but then the Democrats shot and killed a large number of them and lynched a few of the others.
Yeah. So basically, I have there's a drawing from Harper's Magazine, which was in the video. This is a body that basically burying the dead. They lit the courthouse on fire, and people actually made out they were shot. If you want to read a book, it's called The Day Freedom Died, The Colfax Massacre. It's a hard read, but it talks about this incident. Okay. So what happened afterwards, right? Is that Caitlin? Did the Louisiana government prosecute these individuals for lynching and killing hundreds of people?
They didn't.
Okay, but yeah, this is my next question. Okay, thank you. The local Louisiana government did nothing, and this is not to be expected, right? In fact, most of these lynchers were actually government officials, right? They were part of the local militia, right? So they were basically acting under the color of state law, right? These weren't just random people. You know, you think of like the Ku Klux Klan as like this private organization. At the time, the Klan was mostly state militia. These were mostly former Confederate soldiers who were the state governments weren't well formed, but they were state actors for purposes of law, and they were engaging in this sort of massacre. Okay, so Caitlin, you already anticipated my next question. The state didn't charge these guys with murder. Who charged them instead? Okay, the federal government. And what did they charge them with, Caitlin?
They were tried under the Civil Rights Act of 1870 for lynching.
Specifically, what were they charged? It wasn't a crime to lynch, right?
It wasn't murder.
So what were they being charged with, right? There was no federal murder statute.
Depriving them of their rights.
Yes, very good. Today we have federal murder statutes, right? You may ask Josh, what's a federal murder? When you shoot a bullet across state lines? Well, maybe. But generally, if you use a weapon that traveled interstate commerce or some sort of wire, I don't exactly even know what a federal murder is, but they have them every now and then. You know, for example, the marathon bomber. Remember the Boston Marathon bomber from a couple years ago? He used these the pressure cookers. Remember he made these bombs out of these pressure cookers. They were charged with federal crime because they used what they called a terroristic device. So depending what kind of weapon you use. So today we have federal murder statutes. They didn't have federal murder statutes back then. So instead, the federal government charged Cruikshank, Mr. Cruikshank, with depriving these people of their rights. That was the crime they had. They didn't have a murder charge, right? If they were charged with a federal murder statute, it would have been easy to make. That law didn't exist. It wouldn't exist for some years. So instead, they were charged with depriving these individuals of their civil rights. Their First Amendment right to peaceably assemble, and their Second Amendment right to keep and bear arms. That is, these people were doing nothing more than just going into a courthouse and being where they're supposed to be, and they were keeping their rifles for defense of person and property, right? That was the indictment. Okay. In order for this indictment to be proper, right, they would have had to violate the Privileges or Immunities Clause. So the question presented was this: was the First Amendment, the right to peacefully assemble, a privilege or immunity of citizenship? Was the Second Amendment, the right to keep and bear arms, a privilege or immunity of citizenship? If these rights were not privileges, Cruikshank did nothing wrong, right? Cruikshank only violated this provision if, in fact, the First and Second Amendment were there. Again, there was no federal lynching statute. There was no federal murder statute. This was the only way the feds can go after these guys, for depriving people of their civil rights. Everyone understand with me so far? Everyone get me? Okay. So Katie, what happens here in U.S. v. Cruikshank?
The opinion?
Yeah, majority. Chief Justice Waite.
So Waite said that the right to peaceably assemble existed long before the adoption of the Constitution.
Good.
So it didn't derive from the rights given federally, so it wasn't protected under the 14th Amendment.
Very good. Thank you. The court holds, in short, that Barron v. Baltimore is still good law. Barron is still good law. That the Privileges or Immunities Clause does not protect the first 8 amendments to the Constitution. In other words, Slaughterhouse was correct. And the only things protected are, Antoine told us a minute ago, the sub-treasuries, the protection of the high seas, the protection of foreign countries. These sort of insignificant federal rights. It does not include protection against a state from lynching for violating civil rights. So you see this 1, 2, 3 punch. You have Slaughterhouse, you have Bradwell, and you have Cruikshank, decided within a couple years of each other, right? And these 3 cases basically kill the Privileges or Immunities Clause, right? I don't say that lightly, but Slaughterhouse rejected the idea that sort of Article 4 privileges and immunities were protected. Bradwell said, no, the Civil Rights Act of 66, you don't have the right to exercise your trade. And then you have the Bill of Rights. Cruikshank said, no, Bill of Rights is not covered by the Privileges or Immunities Clause. These three cases decided only 2 years apart, 73 and 75. These three cases rendered the Privileges or Immunities Clause a nullity, right? That now the states could violate the Bill of Rights, and the states could violate sort of unenumerated rights of property. This decision didn't cause Jim Crow, but they allowed Jim Crow to develop without any sort of intervention by the courts, because the courts were not willing to scrutinize state police power legislation that existed at the time. Yes, Roche, go ahead.
Would it be fair to say that the courts basically suspended any checks on the states?
Pretty close to it, yeah. I think that the courts were more or less out of the picture. Braden.
Just to clarify, in the heart of Atlanta in those cases, when you were talking about the Civil Rights Acts, that came prior, and that's why they had to justify it under the Commerce Act, you're specifically talking about
so what gets complicated is that there are a lot of Civil Rights Acts. In heart of Atlanta, we had the Civil Rights Act of 1964. Bradwell and Slaughterhouse concerned the Civil Rights Act of 1866. We'll do another case next week that was the Civil Rights Act of 1873. I might be off on the year. But there were a lot of them, and they're numbered. Unfortunately, I have to remember them. I think it's 73 is the other one. But there are a lot of different Civil Rights Acts. But Braden's correct. When we did Heart of Atlanta, the reason why the court had to rely on the Commerce Clause was because of these sorts of decisions that said, no, the states are not limited in any way. I want one more point. They mention, who's next? Yeah, Jamie, thank you. It's my dad's name, I should remember it. But he spells it Jaimie, which is a very unique spelling. You ever see that one before?
No.
Yeah, my grandma wanted it to be unique. I don't know. Jaimie. So, Jamie, let me ask this question, please. They mentioned the Civil Rights Act of 66 at the very end, right? Because remember in Slaughterhouse, they said, well, there's no indication this is being based on racial discrimination. My God, this case was racial discrimination. If there was ever, like, a case involving deprivation of rights based on, race, this was it, right? Has the court so they addressed it at the very end very quickly. They do it. What happened?
Is it that there was no question that was already that it was intended for the protection of the citizens of the U.S.?
No. They mentioned the Civil Rights Act of 66 at the end. You know what happened? Yeah.
They say that they weren't, these atrocities weren't committed against them because of race. It was just citizens against citizens, and obviously there was a political dispute. So that's
Yeah.
justified.
Yeah, so at the very end, right? Yeah. At the very end, the court says, it is nowhere alleged in these counts that the wrong contemplated against the rights of these citizens was on account of their race. Now, what are they basically saying? When you're charged with a crime, right, it's something called an indictment, right? This is a document you present to a grand jury, and the grand jury says, okay, we can go ahead with charges against John Smith for violating X, Y, and Z. When they indicted Cruikshank, they charged him with violating their civil rights, but they didn't think to put in the fact that this was done because these people were black. They just didn't do it. And the court says, well, we will limit our review to the four corners of the indictment, and therefore we cannot find any violations of Civil Rights Act of 66. Which is, it's a stunning holding, right? In other words, to go through these three cases, you have to, like a horse they put blinders on a horse. You know what that is, right? They put these little things on the side of a horse. They only see forward because they see the side. They might get distracted and run away. I see these decisions in a similar fashion, but the blinders were put there quite deliberately because the justices, they did not want to go down the road of actually giving this provision its full weight. Because were they to give this provision the full weight, then the lynching of what would happen in Louisiana would be in federal court, and there'd be a lot more of those. Right? Cruikshank was a test case, didn't work out. So they can't bring these next lynching cases next time, right? This one didn't work out. If Slaughterhouse went the other way, you'd have all these challenges to health and safety laws, right? If Bradwell went the other way, my goodness, you'd have women running to federal court and saying, "Ha, I want to vote." And indeed, there was a case. It's called Minor versus Happersett, MINOR versus Happersett, HAPPERSETT. It might be off in the spelling, where a woman said, "Aha, look." Voting is a privilege or immunity. Give me a ballot, right? I'm a citizen. And there were actually some local jurisdictions started giving women ballots, and then that didn't work out. They said, no, you can't do that. So we had a suffrage amendment later, but the court was just not willing to go along with a broad reading of PRI, privileges or immunities, out of a fear that it would change things too much. And eventually the court would more or less get there. And let me explain how. PRI was basically read to be a nullity, right? They killed it. We'll do cases next week involving equal protection. We'll do Dred Scott, not Dred Scott, sorry, Plessy versus Ferguson next week. And Plessy established what's called the separate but equal doctrine. The notion that so long as you have accommodations that are separate, they're okay if they're equal. Okay. So number 2 is dead, number 4 is dead, right? Those were basically struck out of the Constitution. What happens at number 3, the Due Process Clause would pick up the slack. That a lot of the cases from the early 1900s where the court sort of intervened in the legislative process were not PRI cases, were not equal protection cases, they were due process cases. And in many regards, it's backwards, right? PRI was supposed to be the crown jewel. It came first. This was like the big one. But instead, the court put a lot of weight on due process. Specifically, what is the meaning of the word liberty? And this gave rise to a topic we mentioned last class called substantive due process. Substantive due process, the idea that the word liberty protects rights. Now, which one of these clauses protects rights? And the answer is PRI. These are the rights that are protected. But instead, the court turned to another provision about process to protect rights. Right? And what are the rights protected? What are the liberties protected? The court would hold eventually the Bill of Rights. That the provisions of the Bill of Rights are liberty, which a state cannot deprive you of. And throughout the 20th century, almost the entirety of the Bill of Rights, almost all of it, was incorporated, was extended to the states. So today, Texas, New York, California cannot violate your freedom of speech. They cannot violate the due process clause. They cannot violate the liberty protected by the freedom of speech. Okay? Not because of PRI, but because of due process. You had a series of cases throughout the entire 20th century that said, this right's fundamental, so it's protected, and that right's fundamental, so it's protected. But the court never went back and said the reason why we have this doctrine of extending the Bill of Rights is because of PRI. Only Justice Thomas in McDonald was willing to accept that result. We had a case the court argued last week about whether what's called the right of having a unanimous jury verdict, right? Is that incorporated? We're still arguing these cases now, 100 years later, all because Cruikshank screwed it up at the outset. Okay. Questions? Questions? All right. So over this weekend, is this your Langdell this weekend or next weekend?
This weekend.
Yeah, I'd encourage you to take a solid look at the midterm. Take a look at it. Review it carefully. You may not know everything because, let me explain. Every semester is unique, right? I can have the exact same syllabus, and I may mention something today that I didn't mention last year. And last year the exam was based on what I told my last year class. I write a new one every semester. So it may not be exactly what you learned, but it should be close enough. And just don't pack up yet. I'm almost done. I want to just give you some thoughts on the exam pedagogue about it. All right. Let me actually just pull it up just so you have it, and then I got 10 minutes left. I can walk you through this. Syllabus. Okay. So you have a midterm, fall of 2018. So you have 3 links. Okay. You have the midterm. You have the A+ answer and the memo. Don't look at the answer in the memo first, please. Don't cheat. You can, but you shouldn't do it. The first thing you should do is go over the actually download the midterm. Okay, I'll pull it up for you. The midterm, my friends, is 90 minutes. I used to give it in class, so you'll take the same amount of time. I encourage you to do it 90 minutes straight. Don't do half an hour and 20 minutes. Just do it straight. You'll help yourself out immeasurably. Also, keep your word limit. You can type it in Word. I don't really care where you type it. We have 1,000 words. Get a sense of what 1,000 words feels like. It's not a lot. And you think, oh my God, Josh, how can I do an exam in 1,000 words? Let me tell you something. I just submitted a brief to a court that was 1,500 words. A brief in a very important case. You have word limits as lawyers, my goodness. Right? You have word limits as lawyers. Right? You might have to go to court and write a 3,000 word brief. Your exam, you get 2,000 words for basically nothing, right? I mean, honestly, nothing, but it's not very important, right? So the word limit is beyond reasonable. I used to have a 500 word limit, but I changed. People got too annoyed. I think you do in 5, but whatever. Again, completely open book, bring whatever you want. All my exams look the same. They all have the exact same format, right? It begins, here's the year. Now, I might say the year is 2019, which means you have all of your present-day cases. Or I can say the year is 1802, right? Why is that important? Well, I like to do this. I like to give you an early date where you don't have a lot of cases to rely on, right? I want you to see how you reason as a matter of principles. It's very hard to do this, which is why I ask it this way. This year is 1802. You might not remember this, but Marbury v. Madison was 1803. Deliberate. In fact, the Supreme Court wasn't even in session in 1802. It's made up. But this is a situation where you're the law clerk for Chief Justice Marshall, and there's a conflict at the bank, right? Now, you say, wait a minute, Josh. McCulloch v. Maryland was it 1819, give or take. Might be off in a few years, right? McCulloch v. Maryland was 1819. How can I talk about the bank? Well, if you recall, Washington, Hamilton, Madison, Jefferson, they debated the bank before McCulloch. You know this. Right, so this question will rely, I'll give you a hint, I shouldn't maybe, but this question will rely on your ability to actually bring the debate from Hamilton, Jefferson, and Madison. The way it works is like this. There are 5 questions, and I'll usually give a paragraph or 2, question number 1. Right, a paragraph or 2 in question 2. A paragraph or 2 in question 3, right? Okay. Go through each question one at a time. I'd encourage you to just read the exam straight through once. The reason why is that there might be something in question 2 that gives you a hint and jogs your memory in question 1. So read the answer through straight once. If you have time, read it through twice. It's short. I mean, look, guys, the entire exam is about a page and a quarter, right? Maybe a page and a half. So it will not take you very long to read. So I would read the entire document from start to finish twice. As you're reading, you should be putting little notes in your margin saying, oh, this reminds me of Gibbons, or this reminds me of McCulloch, right? Try and see what case does this remind you of. And one thing that a lot of my students do that's helpful is I'll make a little cheat sheet where I'll have a list of all the cases with the year next to it in chronological order. I'd encourage you to make something like this for your notes, right? Saying, oh, this is like, McCulloch. What year is it? Oh, 1819, right? You don't have to remember the years. I won't be that insane, but you should at least know the names of the cases. And then start writing. You have 1,000 words, and you have 5 questions. Duh. 200 words per question. That's not fixed, right? You don't have to do exactly 200. But if you write 500 words for your first answer, you're going to run out of space. And the worst thing you can do, my friends, is go back and delete stuff because you've wasted time, right? You've written stuff which you get 0 credit for, and the act of deleting it takes time, which you can't write other stuff. So try and, as you're writing, say, oh, it's about 200 words. What's 200 words? About a paragraph, 5 or 6 sentences, give or take. It's not a lot, right? 1 second, Nick. Right? So how do you do this? Well, you're taught in legal writing IRAC, right? The issue and the rule and the analysis. I would focus on the A, the analysis. That's where the money is, right? That's where the money is. I don't need you to restate the facts. I know what the facts are. I wrote the exam. I know. Look, you can give me the facts, but you're wasting time. I don't need to know it, right? You're not padding my answer like you're padding other exams. You can't do that here because of the word limit, right? The word limit doesn't allow you to pad. Okay, Nick, what was your question?
When we're answering questions that are pretty much based on first principles, do you suggest we know the Federalist numbers?
If we cover it in class, yes. I mean, I don't expect you to cite a Federalist we haven't studied, but I've assigned a couple of them, and those would be good to cite. We talked about the ratification of the Constitution, right? On the first day of class, I walked through a lot of stuff, which you might want to go back and revisit. That comes up a lot. Okay. Just FYI, I think the first question you may not be ready to study quite yet. So if the first one doesn't make a lot of sense, that's okay. I think the first one involves a case we haven't studied yet, but you can at least give it a go. Every semester we're at a different level. We the storm, just holidays line up. We had a lot of Jewish holidays this semester, which puts a little further. I'm not complaining, but I think we're about a week behind where we were. But question one may not be the easiest, but the other one should be okay. Yeah.
On your exams, you list them out all the way to 2015. Should I focus more on the earlier ones or the newest ones? Or does it really matter?
You know, it's a good question. ConLaw is one of those. If you ask me this in property, I'd say it doesn't matter. ConLaw does, because I switched to the Barnett book around 2015 or so, or 2016. So the older ones are going to be less helpful because a lot of cases I don't teach anymore. Again, you may take the exam and say, what the hell is he asking about? That's because that year may have mentioned something I didn't mention for your year. So you have to just be considerate of that. But it's more important that you actually suffer than actually get the right answer. The right answer is actually less important than they actually suffer through it. A couple other notes, if I may. The last question, what I call question 5, I call it the policy question. I always put a policy one at the end. Policy doesn't mean let me just write whatever the hell is in my head, right? Policy still requires you to understand the case law, but it's a little bit more high level. You know, for example, this one said, discuss the Supreme Court's ability to resolve sectional conflicts between the federal government, the northern states, and the southern states, right? Think about what we've talked about. Like, there's not one right answer here, but there are certain cases or certain concepts we've talked about. There's certain issues in which the North and the South didn't agree, right? The federal government and the states did not agree. How can the court resolve those? But again, this is 1802. You don't have Dred Scott. You don't have Prigg, right? You don't have Slaughterhouse. You don't have these cases. So how can you answer it? And that's what I want you to think about. Yeah.
Could we, for instance, take, because it's in 1802, McKelvey, Maryland has not happened, could we rely on how Justice Marshall would rule?
I would not do that. It's risky, right? Again, you have to basically argue this as if you were in 1802 and that's all you know. A lot of students try and get accused, like, well, here's how the court will rule in 20 years. I don't give much credit for that, right? Because it's cheating. It's not cheating, but it's not answering the question I want, right? Now, after you do the exam and before you come meet with me, I encourage you, please do this. Download the A+ answer and download the memo. The A+ answer, and I'm going to go about a minute over. If you need to run, that's fine, but I want to make sure I get through this before your weekend. The A+ answer is what I call the hybrid. I used to take whoever got the A+ and just paper, but that wasn't a perfect paper. I've never had 100. It's never happened. I've never had a perfect score. I think I've had a 93 or 94. It's about the highest as it gets, right? So maybe you'll get 10 out of 10 on part 1 and only 8 out of 10 on part 2. What this hybrid answer is 10, 10, 10, 10, 10. People got 10 on each of the 5 parts, right? So of course, there are 5 questions. Each one's worth a maximum of 10 points. That means 50 perfect, and the final is double that's 100. What makes a 10 versus a 1? I don't give a lot of 10s, they're rare. But the 10 answer is usually the person who sees all the cases I'm talking about and manages to explain why my facts are similar to or different than those cases, and incorporates some of the more policy arguments about the importance of federalism, or the importance of separation of powers, sorts of deeper issues, right? If you read the A+ answer, you will see very clearly what I'm looking for. It's going to be very obvious. Now, one obvious note, because I mixed and matched different papers, this goes over 1,000 words. So please don't complain about that. I know it. I know it's not. It's going to be over 1,000 because people allocate their space differently. All right, so after you do your exam, please compare it to the A+. If you come to me and you haven't done that, I'll send you back and say, please review it. So just save ourselves the time. But go over the A+ answer. And then read the memo. The memo is about 2 pages long. And I just tell you what I'm looking for. And the reason why this is important is it gives you an insight into my mind of how I write the questions and why I'm asking what I'm asking. The key of doing these sample tests is not to get the right answer, but to figure out what it is that I'm looking for and how I go about these things. Okay. Questions? All right, I'll be in my office now for the next hour, so if you want to come by. Otherwise, I'll see you all next week. Thank you so much. Oh, right on time, 11, perfect.